What's up, everybody? Welcome in to another day of the Karen Reed trial. The Commonwealth finishes its last witness, and the defense gets to begin their case. We've heard so much about it. We heard so much about what they're going to prove, how they're going to prove it, a bunch of experts, maybe some lay fact witnesses. We get to jump into the defense's case today, and it may be over quicker than you think, because another interview was done with the attorneys at the end of the day, and they gave us some insight into who is left for them to call. And does it include Karen Reed? Go ahead and hit that like button and let's get started. So we continue with the medical examiner's testimony at the start of the day. And she basically says that she reaches out to law enforcement for clarification a lot of times if the death was unwitnessed, which happened in this case. She spoke to Proctor a couple times. She didn't feel like she was pressured into giving a specific cause or manner of death for this case. They go through photos of the body. And while they're doing it, people are, of course, talking online, on Twitter, and the media about the lack of emotion in Karen Reed. They zoomed in on John O'Keefe's brother, and he looked very angry as he did not look at the screen, but instead looked like he was staring at counsel table. Incredibly sad situation here from the jump today to remember the lack of justice that it feels like is going to come to John O'Keefe, regardless of what the outcome of this trial is, based on the investigation and law enforcement in this case. She talks about how it could have been, any blunt force object. It could have been any fall or injury, whether he was projected to the ground, fell on the ground, hit the ground, and that the arm injury is possible from glass or plastic or metal. Basically, it could be anything. And it feels like Lally doesn't realize that that's not good for him because he keeps asking these could have possibly been this type of questions when it's his job to prove matter-of-factly exactly what happened and how it happened in this case. But at the end of her direct, they basically go through her testimony again, which parts of it was not great, but it was definitely repetitive. And we're going to talk about more how basically every single expert, Lally has got them to say multiple times what their opinion is over objection by the defense. The judge overrules it, and then we'll revisit that when the defense tries to do it, see if the judge handles it the same way.
The arm injuries that you observed, would those be consistent with scratches from either glass or a piece of plastic or a piece of metal?
It's possible.
And the injuries that you observed, would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
Why would he ask that question? Like maybe he knew the defense was going to ask it, but I would not ask that question if I knew the answer was no. He's like, would this be what you would expect for a pedestrian accident injuries to look like what happened to John O'Keefe? And she's like, no, it's not commonly what we see in pedestrian accidents. It's like, okay.
And to that point, as far as when you say classic, as far as a pedestrian collision is concerned, you've conducted autopsies on a number of different pedestrian collisions over the course of your career. Is that correct?
Yes, I have.
Do they all sort of mirror each other? Is there sort of a disparity depending on how the person interacted with the car?
Objection.
Sustained. Watch the form, Mr. Lally.
What, if anything, are every injuries from a pedestrian collision the same?
No.
And why not?
It depends on many factors. It depends on the position of the body, of the pedestrian or the person being struck. It depends on whether they are moving or standing still. It depends on the speed of the car. It depends on whether brakes were applied or not. There's a lot of factors that come into play.
Would another factor be sort of the shape of the vehicle that strikes a pedestrian?
That's also possible. Yes, that's a factor.
And did you have occasion
so
to...
obviously, all car accidents are not the same. All pedestrian motor vehicle accidents are not the same. But for her to say this is not typically what we see, I don't know how that helps the Commonwealth. Ashley said, thoughts on the ME saying she's not a biomechanical engineer or accident reconstructionist. Think the defense should bring that up to Bev so the experts can opine on number 4. I don't think that's changed. What I do think they will definitely do based on some of her testimony is explain the differences in experience and training and education that make them more equipped and experts on giving testimony she was not able to give. I don't really think a lot of what she said hurt the defense.
See any photographs, or have you seen any photographs in relation to the defendant's vehicle in this case?
I have seen photographs, yes.
And the size or shape of that vehicle, what, if any, significance did that have to you as far as your exam?
Objection.
I'll allow it.
When we have a potential vehicle, clearly we look at the height because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs, because in the majority, we see injuries to the legs from the bumper of.
So why didn't we see that here? We know John O'Keefe is 6'1", 217. Why do we not see that here? Why is he asking these questions? Yes, of course, the shape of the car is important. Why doesn't it correlate to the injuries in this case? Like, we can't just forget that. And again, I'm probably going to say some things at the end of this video a lot of people aren't going to like about how Lally handled one of the witnesses and how I thought it went for the Commonwealth versus how it went for the defense. People can probably disagree with me, but we can't forget the fact that they just will not tell us how this all lines up and makes sense outside of Paul saying, yeah, I think he might have been holding his glass like this and, got hit and projected 30 feet. That's all we have. So that's what we have to take and listen to. When the Commonwealth tells us what their case is, we have to listen to them. We cannot create what we think it actually is if it's not what the Commonwealth is saying. If you do not believe this happened the way the Commonwealth proved it to you with the evidence they presented, you have to vote not guilty.
The car, again, depending on the kind of car, the size of the car, and the height of the bumper. So in Mr. O'Keefe, I did not see any injuries in the lower extremities. And looking at the car, I did note that it was a much bigger car with much higher, I would say much higher taillight bumper. It was not a sedan or a car that's low to the ground where the bumper would be at the level of, let's say, the knee or.
So show me measurements. Show me measurements of how that correlates with the scratches on O'Keefe's arm. Why is that so hard?
Slightly above or slightly below.
And again, I believe yesterday in your testimony, you indicated that the skull is a pretty thick bone. Is that correct?
Yes.
Sustained.
Anytime a lawyer, by the way, says, and again, you said yesterday, so lawyers sit there and we're doing 15 things at once. We're reading, we're listening, we're talking to co-counsel, talking to our client, taking notes for cross, whatever. But whenever there are certain words that are just triggers, like, what did this person say to you? Objection, hearsay. Again, can you tell us objection, cumulative, or asked and answered?
To the thickness of the skull bone, what if any significance, or what if anything you say as far as the type or amount of force that would be necessary to cause the fracture that you observed?
Objection.
Overruled.
Of course, she overrules it, even though she absolutely should not, because this witness is about to tell us why she's not qualified to answer this question, yet the judge allows it. I don't understand it, especially how she limited the defense expert's testimony all over the place.
I would consider the amount of force to be significant, again, without being able to quantify it.
So you don't know. You're not able to answer that. Okay, and that's basically her answer. Then we get to cross. Blunt force injuries can happen a ton of ways. From a bat, from a weight, from the floor, from claws. Very weird to me that claws and the glass or plastic shards from the light, she says, are a blunt force object. I thought like the definition of the opposite of blunt force object was sharp, razor, rigid, whatever, which claws and glass would be. So that was kind of weird, but she said it was whatever. It could be from a lot of things, obviously. And in cross, I thought Ms. Little did a really good job going very specifically and methodically through all the injuries that did not exist below the neck. Because I've heard a lot of people in here argue with me, oh, he had this bruise or this hemorrhage or whatever. He absolutely had injuries below the neck. They were just internal, not external. I was like, okay, there's even a bruise, later in the lower body and whatever. Well, she goes through all of it and has the Commonwealth's ME confirm exactly what the defense wants this jury to know.
You've testified similarly that blunt objects can also refer to a large range of objects. Is that right?
Correct.
And I think yesterday you gave the example of a microphone being a blunt object.
Correct.
It could also include something like a baseball bat,
Correct.
a dumbbell,
Could be.
the ground,
Yes.
or a German Shepherd's claws.
Claws. Possibly, yes.
See, she says yes to that. It's kind of weird. I'm like, are they?
You'd agree
Oh,
that
maybe she
John
said paws, not claws. I don't know.
O'Keefe had a number of blunt impact injuries on his face, on his head, and his right arm.
Yes.
Besides his right arm, which we'll discuss in a second, taking his body from the neck down, he did not have any significant injuries.
From the neck down. Not significant, no.
Let's take those one at a time. No injury whatsoever to his shoulders.
Correct.
No injuries whatsoever to his chest area, aside from sort of the CPR-related injuries that you discussed.
Yes, correct.
And that was in the sternum. Is that right?
It was in the ribs, just adjacent to the sternum. Yes.
No injuries to his torso, other than that?
No.
No injuries to his back?
No.
No injuries to his hips?
Correct.
No injuries to his pelvis?
Correct.
No injuries to his thighs?
To his,
Thighs?
No.
No injuries to his knees?
correct.
No injuries to his shins?
Correct.
No injuries to his ankles?
Correct.
No injuries to his feet?
Correct.
From the neck down, he did not have a single broken bone, again, aside from those CPR-related injuries you discussed, correct?
That's correct.
Not a single fracture.
Other than CPR, correct.
And you spoke earlier about how the bumper was a little higher than on, say, a regular sedan, correct?
Correct.
And so usually in a pedestrian collision, you would see injuries to the knees, is that right?
Objection.
I'll allow it.
Depending on the kind of car, depending on the speed, depending on the height of the individual and the car, you might see injuries to their lower extremity. Yeah.
But in this case, you didn't see any injuries to his thighs, to his pelvis, anything even at the height of the bumper, is that correct?
Correct. A very minor abrasion to the side of his right knee.
So surely you'd agree that John O'Keefe's injuries, or lack thereof,
By the way, that very small abrasion to the side of his right knee, Lally brings up in redirect to make sure, we all know that existed, as if that's what you would expect when a 7,000-pound vehicle hits you at 25 miles an hour.
are inconsistent with having been struck by a 7,000-pound vehicle at 24 miles per hour and being projected 30 feet.
Objection.
Sustained. Break it down, ask it differently.
Would you agree that John O'Keefe's injuries, or lack thereof, are inconsistent with having been struck by a vehicle at 24 miles per hour?
I would say it's likely and unlikely at the same time, depending on the position of the body and the vehicle in question.
Well, let me give you a hypothetical. Let's say the person were standing with their arm like this, and they were struck by the rear taillight.
By the way, we can't see her, but I assume she's acting out how Trooper Paul said John O'Keefe was hit.
Of a vehicle at 24 miles per hour. Would you agree that his injuries are inconsistent with that scenario?
Objection.
Sustained.
Because it makes
Maybe approach, Your Honor. Sure.
absolutely no sense. They approach for a second. We're going to skip through that.
Would you agree that John O'Keefe's injury to his arm are inconsistent with having been struck by a vehicle at 24 miles per hour?
I don't know. I am not a reconstruction expert. I'm not.
No, you're not. I have a feeling that if Jackson was cross-examining this witness, he would have said, no, you're not. He likes to do stuff like that. You're not an accident reconstructionist expert, are you? We have one of those. Just wait.
Not a biomechanics expert. I never
No, you're not. But don't worry, we have one of those too.
personally inspected the car, so I can't offer an opinion on that.
You did examine John O'Keefe's arm, correct?
Yes,
You observed no significant bruising,
correct,
no fractures,
correct,
and no broken bones.
correct.
It's very interesting. She also talks about how the minor injuries, while they might not be the cause of death, they can help us determine the cause of death sometimes and the manner of death.
Right?
Absolutely.
They have to originate from something.
Yes,
Would you agree that his injuries to his face are consistent with having been punched?
that is a possibility.
And now, again, we're going to go through all the possibilities. And this whole possible outcome thing is not created equal between the defense and the prosecutor. The defense is fine with all the possibilities, and they hope the jury is thinking exactly what Toots is thinking here. I think it was actually just a fall, accidental fall. Because great, guess what? That means not guilty. Or somebody thinks, I think it was a fight. Guess what? That would be not guilty. So all of these possibilities that could create a not guilty is great for the defense. Z said, can the defense open their own door? No, can't open your own door. Rebecca, hit head on grass unless he was bending over. What did he hit his head on? I have no idea. The defense is saying on a weight bench or something in the basement of the house. The prosecution's saying on the frozen ground. I don't know. Jazz said, what's the longest criminal defense you've seen? I've seen criminal defense attorneys put up multiple weeks long of trials, but it's usually less than the prosecution. That's not unusual.
You can take that down, Mr. Bates. Thank you. Your internal examination notes also cite a tongue laceration on the right front of the victim's tongue. Do you recall that?
Yes,
And you'd agree that a tongue laceration can be also caused by blunt force trauma.
correct.
And that could also include something like a punch to the victim's face or jaw.
That's a possibility.
In addition to the facial injuries, you described that Mr. O'Keefe had a significant laceration on the back of his head.
He had one laceration to the back of his head, correct.
So we saw a photograph of that
Yes.
a little bit earlier. You testified that the skin around the laceration on the back of his head was also scratched. Do you recall
Yes.
that?
I do.
But you did not testify as to how you opined that might have happened.
No.
Would you agree that someone could certainly get scratched on the back of their head if they were, for instance, dragged on the ground?
It's possible.
It's a Commonwealth witness. It's possible that they have a scratch by that abrasion if they're dragged on the ground.
You described the open wound to the back of his head as a laceration, which is sort of a blunt force injury that's not the result of sharp force trauma. Is that right?
Yes.
And you'd agree that Mr. O'Keefe's head injury came from some sort of blow to the back of the head, whether it be an object or the ground. Is that right?
Yes.
Objection.
And that injury could be the result of falling backward from a standing position onto concrete.
It's possible.
It could also be the result of being struck with a large object, such as a baseball bat or a barbell.
It's possible.
In other words, it was an irregular laceration that resulted from some blunt force trauma.
Correct.
I'd like to sort of circle back to those injuries to Mr. O'Keefe's arm. You testified that there were, again, no fractures, no broken bones, no significant contusions.
Correct.
But you did describe the wounds to Mr. O'Keefe's arm as having discrete linear abrasions, which were caused by some sort of blunt object, correct?
Yes.
What does discrete mean?
It means each one is an individual injury as opposed to.
Unlike road rash, if you've ever seen it, when you scrape, it's almost like it all goes together, but some of the rocks in the road are bigger, and so they make bigger scratches. These are almost like separated by fingers. That's what the defense is trying to get the jury to understand.
To confluent, where it would be all meshed together.
Your Honor, if I could publish what's been previously marked as Exhibit 19, okay, referring to.
Yes.
And you testified that these also sort of appear in clusters or groups. You call
Yes.
them pattern abrasions. Is that right?
Yes, I did.
And you'd agree that, for example, road rash does not result in this type of discrete linear wounds.
It could, but not exactly like this.
Well, typically road rash covers sort of a large area of the skin. It would be a large abrasion. I mean, you've seen numerous cases of road rash in your
Yes.
career. And it doesn't look like that.
Correct.
Blunt force trauma can include injuries from various objects, as you testified, including an animal paw, correct?
Correct.
And you'd agree that these discrete linear abrasions are inconsistent with having been struck by a smooth rear taillight at 24 miles per hour.
Objection.
Can you answer that, Doctor?
I can't. By
Okay.
smooth, no.
All right, next question.
She says by a smooth no. I didn't know if she meant no, it couldn't happen, or no, she couldn't answer it, but the judge does not allow her to answer it.
By a smooth rear, you don't know what caused those.
I think that's it. That's all I wanted to play from this part. She does talk about how some of the marks on his hands could have been from defensive wounds, and that's not where she said that's not where they put the IV in. She doesn't believe injuries could have been from a single blow to the head or multiple blows to the head and face. In the grand jury testimony, she testified that the head injury was likely from a fall, just different than being beat up and different from being projected. It sounds like a slip and fall or trip and fall, but it could also be after getting beat up or after getting hit by a car, right? So it kind of leaves it open and ambiguous for the state to fill those holes. She ends with something like, is it possible for someone to get hit in the face and then fall? And of course, the witness says yes. And then she does finalize with, there was a spot that looks like a bruise on the trunk of the body or something that's blood pooling, not an injury to that part of the body below the neck. Then on redirect, he says something like, well, you did see that minor abrasion on the knee, which we already talked about. He talks about more possibilities, glass, plastic, things like that. And then he wants to know, he wants to get an answer out of her. She doesn't give him the right answer. So he, again, pulls his dirty move that after 29 days or whatever of trial, the judge is like, hey, watch your form of the question, Mr. Lally. It's like, he's not watching it. He's doing it on purpose, but I give this witness a lot of credit. She didn't just listen to the question he gave the answer in and repeat that. She tried to just answer it better with her own words. So I do respect her for that.
You asked about certain wounds as being a possibility of defensive wounds. What are some of the other types of defensive wounds that you would expect to see that you've not seen in this case?
I would expect to see, or I have seen, multiple bruising to the, again, posterior aspects of the forearms. I have seen cuts, lacerations, depending on how a person might be defending themselves, the position of their arms.
He wanted more. So how's he going to try to get it? She answered the question already. She's already answered it.
And that also includes breaks in the fingernails and fractures to the hands.
Objection.
Watch the form, Mr. Lally. Sustained.
That's what he wanted her to say. breaks in the fingernails, fractures to the hands, things like that.
What, if anything else, would that include?
It might include bruising to the knuckles. It might include broken fingers.
She tries. She does her best to not just repeat what he said, and I respect that. Then he asks her to tell how these injuries came to be, and she's like, I don't know. All I know is he hit his head. And that's that. And that's what the Commonwealth rests on. I'm going to answer a few questions. Then we're going to get to the JOA arguments by the defense and my thoughts on them, which may surprise you, may not. Tim, where in the law does it forbid expert witnesses from stating his or her opinion, looking at you, judge, objection sustained? So they are limited. Once you're an expert, you're not just an expert on everything, but I don't understand some of the limitations by the judge in this case. Will the judge let the biomechanical testify about the injury? We'll see. It seems like she's not going to let him testify about the head injury potentially. I think she's going to let him testify about a lot, so we'll wait until we hear that. Kevin, ready to say cover up, Peter? Hold, because there's a witness today that I actually think makes me go even further away from thinking the cover up is going to be proven beyond a reasonable doubt, which it doesn't have to be, of course. Yes, Yannetti. Head wounds, bleed like crazy. Where's all the blood? Albert, basement floor, which was ripped out and replaced. I don't think that's come into evidence, but if the jury is wondering where all the blood is, I think that's a legitimate question. Yup, that was me. Did anyone swab for DNA the hydrant near the body? Not that I heard of. Patrick, who is the man stuck at the child's table in the rear of the defense team? I think that is their tech guy. He probably wants to be by himself, so he has all of his stuff around and knows it's going to work when they call on him to ask for something specific to be put up on the screen or manipulated. So now we are going to go to Jackson's argument for JOA. Now, there were a lot of things I thought that they could have argued about. No wheel witness. Did somebody actually put her behind the wheel? Was she actually driving? The blood alcohol content. Was that enough? He pretty much stuck to one argument that this is preposterous, and based on Paul's explanation, you can't even prove a car hit John O'Keefe and that's how he died. I got to be honest, legally speaking, I think that is legally insufficient with the evidence viewed in a light most favorable to the Commonwealth. We're probably not going to play Lally's. He just kind of repeats their evidence. And again, it shows how weak their evidence is. But I think the defense knew they were going to lose this. The judge immediately denied it. And I think they're saving the juice for closing. And they think they've got this jury. They know they don't have this judge. And you got to convince the judge. And it's a very tough standard to win under.
Your Honor, I'll be brief. The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury can find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after arresting is insufficient to meet such a finding. There's no question, but with this particular prosecution in this particular case, no reasonable or rational jury could come to a unanimous verdict in favor of the Commonwealth. I want to, if I can, focus my argument on count 1, 2, and 3 and a specific element of each count.
Okay.
In each one of those counts, there must be evidence that the vehicle killed John O'Keefe. There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe. There's been conjecture, there's been speculation, but no actual competent evidence. The Commonwealth's entire case relies on a theory built on
and again, the problem is Paul testifying the way that he did is technically evidence that he's saying based on the backup and things like that and where the light shattered and the injuries to John O'Keefe is all consistent with her car hitting him. So he did say that. The medical examiner did say that this could be consistent with him getting hit by a car and being projected and falling to the ground. So technically that's evidence. Is it reliable and credible? That's not for the judge to determine at this point. But I don't think there's any evidence that we've had people say like, yeah, there was a woman driving, or yes, it was Karen Reed's car we saw out front, or yes, we saw Karen Reed get into the driver's seat at the waterfall. But I don't know that we've seen anybody say Karen Reed was behind the wheel of the car when they were at the Fairview and John wasn't in the car anymore. So she was the only one driving the car, and identify her as the person driving when this all happened. And in Florida, it's like that might not even pass the muster for a simple DUI case, let alone a murder or manslaughter case. So that's pretty wild. David, I agree. Lally wants us all to believe the snow was so bad, but it was just kind of picking up and starting at that point. So it would not have been frozen at 12:25, 12:30, 12:45. I'm not so sure when the Commonwealth actually thinks this happened.
of a trooper named Joe Paul, who testified a couple of days ago. And his theory, according to the Commonwealth, is that John O'Keefe's arm was struck. He was spun around in sort of a pirouette. He was projected 30 feet to the left, hit his head on a curb or the road in the intervening time before coming to a final rest spot about 30 feet away. Everything in the Commonwealth's case, everything relies on that theory of damage to the taillight at the scene. If a rational jury could not unanimously determine that Trooper Joe Paul's theory is true beyond a reasonable doubt, then we believe the motion has to be granted. There is no competent medical evidence to support that theory. There's no competent physical evidence that the taillight could break and shatter in the way that they've suggested, and that the arm would not have any breaks or shatters or any damage, any additional damage. There's no evidence how getting hit in the arm could actually launch a body 30 feet, as per the Commonwealth's theory. And there's no evidence how a body hit by a 7,000-pound SUV could sustain no injuries from the neck down, which we just heard this morning. The evidence before the court.
While I agree with him, that's not the testimony. The testimony is that nobody said there's no way. They said they would expect it. They say that would be consistent with most motor vehicle accidents, but they did not testify that there's no way that there would be injury, that there wouldn't be injuries below the neck. Now, I may say that, and that's kind of what I think, and the jury may believe that, but that's not what the testimony has been thus far.
The only evidence that is before the court is that the Commonwealth's own medical examiner does not believe this is a homicide. And she went on this morning to say that in her expert opinion, the injuries are not classic pedestrian injuries, and they are, every single one of them, consistent with a physical altercation. Calling a witness to simply espouse an opinion like Trooper Paul did that belies science, common sense, or logic, that's not enough to get the case to the jury. The light most favorable to the Commonwealth does not mean that the court must believe the Commonwealth's witnesses. What it means is that if there is a rational controversy in the evidence, the court must accept that evidence that favors the Commonwealth. But here, there is no rational controversy. As put or expressed in Commonwealth versus McCormick, it's a 2023 case found at 491, Mass 848, pinpoint site 860, quote, where the Commonwealth's evidence is entirely circumstantial, it cannot meet its burden if the evidence equally supports inconsistent propositions, as resolution of such a case necessarily requires conjecture or surmise.
Now, I do think this might be a better argument after the defense's case to say that the evidence equally supports other theories, but they haven't presented their evidence at this point. So KPT said Ryan Nagel put Karen in the car with her hands at 10 and 2. So I'm trying to remember his testimony. There was somebody else in the car, I think, that said they saw Karen turning in front of them, but I don't think that was Ryan Nagel. And he said it was a woman and a man. So you're saying when they drove by, he's saying, I remember somebody said the light was on in the car, that he said it was a woman, and not just that it was a woman, that it was in fact Karen Reed. That may be the case. It may be the case with Ryan Nagel. I can't remember, honestly. I can't remember.
In our view, there is no question that there's no rational controversy related to the Commonwealth's theory. Trooper Paul's theory is by definition not rational. It's not reasonable. And it's basically based entirely on conjecture. And that's why, in our view, the court is required to find Ms. Reed not guilty of counts 1, 2, and 3. Because each of the counts, as I said at the beginning, necessarily include an element that John O'Keefe was struck by Karen Reed's vehicle. Thus, if a rational jury cannot reasonably believe Trooper Paul's theory, it's the only evidence presented by the Commonwealth describing how Mr. O'Keefe possibly could have been struck, then Ms. Reed is entitled to an acquittal. Nothing else matters. Nothing else in the court's evaluation, nothing else in the jury's evaluation, nothing. Everything turns on whether or not the car hit John O'Keefe. And the Commonwealth's only theory of how that happened is from Trooper Paul's description. If the court were to deny this motion, then by doing so tacitly, the court is expressly endorsing Trooper Paul's theory of how John O'Keefe was struck, and we don't believe that that's rational. We don't believe.
He says if you deny our motion, then you're basically saying you agree with Trooper Paul. It's pretty interesting. All right. Then we get into the defense's case. Their first witness is a fact witness who provides new details that nobody else has provided, that nobody else could be a witness to, that I found very interesting. People said this guy was going to testify. We've heard his name. I didn't know what he was going to testify to. He grew up in Canton. He's familiar / kind of friends with the Albert family, especially Chris Albert. He delivered pizzas literally for years for Chris Albert's pizza place. And on January 28th, he talks about what he remembers. He checks in. He goes and gets the Franken truck, which, is a lot of different parts put together to make this truck. And he goes and starts plowing and talks about the first time he plowed Fairview, what time it was, what he saw, what he remembers. And again, this is something nobody else has really unequivocally testified to, in my opinion. Everybody else just wasn't looking at the lawn. I wasn't paying attention. I was talking to this person, talking to that person, was looking over here, looking over there. I was drunk, whatever, right? The black blob is all we have from somebody who admittedly was drunk. So what is this witness who says, I was paying attention, my lights were on, my visibility was good, I was doing my job, I was paying attention. What does he say?
From where you are seated now, Mr. Walker, are you able to see what's on the screen?
Yes.
And do you recognize that?
Yes.
What do you recognize that to be?
That is the Albert house, Brian Albert's.
And when you were passing the Albert home on Fairview, the very first time you passed it, would it have been on your right or your left?
It would have been on my right.
What section of the road were you plowing at that point?
The middle of the road.
Why is that?
I sat in the middle and I angled right with the plow.
Now, I want to direct your attention to when you were, your truck was essentially perpendicular to the driveway. You see the driveway in Exhibit 66?
Yes, I do.
When you were perpendicular to the driveway, where were your headlights pointed?
In front of me, in front of the truck,
I'm sorry?
in front of the truck.
And what were
Where all headlights are pointed.
you able to see of the front lawn of the Albert residence that very first time you passed?
I was able to see the entire front lawn.
And about what time was it that you first passed 34 Fairview Road?
About 2:45.
Now, as you continued along past the driveway, did you continue to have all of those headlights on in front of you?
Yes,
And as you continued along, what were you able to see of that front lawn? How much of it?
a very large portion, almost to the front steps.
And
So
now,
basically, he could see the entire lawn, and he confirms that as he's driving by with his lights, which is also important because a lot of people didn't have lights. Becky Z said she thought he was the best defense witness of the day today. Nicole said he was super credible, didn't suddenly forget everything on cross. I liked him. I will tell you, he's the personality and has the demeanor and disposition I really like in a witness or a client, even down to earth guy, normal guy, salt of the earth, hard worker. But when we get to cross, by the end of his testimony, I did think he was maybe closer to mid than, an amazing witness, because I do think some very legitimate things came out on cross that may hurt his credibility, depending on how a jury looks at this case, that we have also said have hurt other witnesses' credibility. And we're going to call it like we see it with this witness. But I think on direct, he was incredibly effective and gave some very good new evidence for the defense to use throughout the rest of the case. And what's most important about him is, and I would have kind of leaned into this more if I was the defense, he doesn't know Karen Reed. He's not friends with Karen Reed. He doesn't want to get with Karen Reed. He actually knows the Alberts. He's from Canton. He's one of them. Karen Reed's not one of us. He is. And he's testifying to this information, which I think is pretty strong.
when you're plowing, where is your attention focused, sir?
My attention's focused in front of me and then to the sides.
Why would your attention be focused to the sides?
I am trying to be aware of any side traffic, any pedestrians, and God forbid, any animals.
And when you were passing the Albert residence, as you pass every home, what attention do you pay to the sides of the road and the lawns that are adjacent to the road?
I'm, again, making sure that there are no animals, no pedestrians, and making sure no one's coming out of their driveways, not expecting to see me.
And with regard to Exhibit 66, do you see the flagpole there?
Yes,
Is that something you had seen previously?
yes.
And when you made that first pass by that residence at 2:45 in the morning, sir, with your headlights on, what, if anything, did you see on the front lawn in the area of the flagpole?
I saw nothing.
If there had been a 6'2", 200-pound man lying in the snow there, would you have seen it?
Objection.
Sustained.
Now, once you pass the residence, where do you go?
I go to the end of Fairview.
And what street does that intersect?
And he continues to kind of explain his route, but at the end of the day, you realize what he's testifying to. He saw basically the whole yard and he didn't see anything in the yard. Therefore, there was not a body in the yard at 2:45 a.m., which is after 12:25, 12:30, 12:45, when the Commonwealth says this happened, and before 5:45, 6 a.m., when the ladies show up and find the body. So if you believe this guy, the case is over. It's legitimately over. Tricity asked, do you think part of them wants to get their witnesses seen anyways? No. It's a huge home run, locked and loaded, big time win if you get this case thrown out on JOA by the judge to show they literally have nothing or that she is legitimately innocent. So they would definitely take that first. But I think they knew they were going to lose. So maybe they didn't give it their best swing. Mother of Beagles, do you think the federal investigation will give some answers for the family, or will we never really know what happened to OJO? Want justice for the family? Just completely guessing. My guess is that federal investigation is going to look at the investigation, not necessarily the cover-up. Tiny E said the jury should now be experts in determining witnesses who are handling something versus credible witnesses. Lucky was credible and likable. So again, I'm not saying that this guy is lying, right? I don't think he's lying, but there are some issues with his testimony. Because he said he did drive back 3:15, 3:30 again. And when he drove back, he didn't see it. And then 3 hours later, he drove back and still, I think it was blocked off at that point because ambulances, Karen Reed, all of them were there. And then his testimony about the Ford Edge, I think, was really important. And again, new details and new actual evidence coming in that the defense will use. Let's hear him testify about that. But we've got to reserve judgment on him until we hear cross, just like we did for all the Commonwealth witnesses.
Be on my right.
And did you take that right?
Yes, I did.
What, if anything, unusual did you see at that point?
At that point, I saw a Ford Edge on the side of the road
Where was it parked on the side of the road?
in front of the Albert's house,
Where in front of the Albert's house?
by the flagpole.
And why was that unusual?
So where John O'Keefe's, ish body would have been, he said there was a Ford Edge there. So, just another possibility, I guess, the defense is throwing out there is maybe somebody else sitting with a car, but they said that's impossible. So I'm not really sure. And also very weird with the defense's theory is like, how do they explain the cocktail glass? Why would they plant the cocktail glass? Like they were really thinking that far ahead. They planted the cocktail glass as opposed to just beating him up and throwing him in the snow. Like nobody would have said anything about the cocktail glass. So the fact that the cocktail glass is there to me is a question mark in the defense's theory. Not that they have to prove it to me beyond a reasonable doubt. They just have to prove it is a reasonable theory, which I think they're on their way to doing. But that's a weird one for me. And of course, the cell phone is a weird one for the Commonwealth's case. How all that ended up there if she hit him going 25 miles an hour in a 7,000-pound vehicle.
The Alberts never had cars that were parked out front, and it just stuck out as weird.
Now, what were the snow conditions like at that point? This is now, I think you said about 3:15 to 3:30.
It's starting to accumulate a lot quicker than what it was previous.
And what policies does the DPW have regarding cars parked in the street during a blizzard where there's plowing to be done?
We are to notify the supervisor. At that point, he will make a phone call to the police, and depending on if they can have the resident move it, it gets moved. If not, it gets towed.
And with regard to that policy, did you comply with that policy in those early morning hours?
No, I did not,
Why?
because I was being courteous to the Albert family.
So, that's an issue. He usually would report something like that. And we find out on cross that he hit a basketball pole and he reported that, but he didn't report the Ford Edge was there like he was supposed to for them to come tow it. But why did he not do that? As a favor to the Alberts. So there's two ways of looking at this. Number one, you can be like, did it really happen? Yeah, right. He wouldn't have reported it, which I think some people would say if he was a Commonwealth witness. Or number two, wow, this guy is incredibly credible because he's doing favors for the Alberts and now testifying in a way that's obviously not good for them.
Now, once you saw the Ford Edge parked on the side of the road near that flagpole, what did you do?
I had to go around the vehicle and as to not hit the vehicle.
All right, and probably obvious, but as you're approaching the vehicle, was it faced in the same direction that you were traveling?
Yes,
And so you're going around to the left or the right of the vehicle?
left.
And once, as you were approaching that vehicle, were you able to see on the right side of that vehicle, but the lawn side?
Yes.
Did you see anything on the front lawn at that time?
Objection.
I'll allow it. Did you see anything?
No.
Lights were still on.
Correct.
All right, now, once you pass the vehicle, did anything attract your attention at all?
No.
All right, where do you go?
I go up to the end of Fairview and do the same process. Take a left on Chapman and back down Chapman and take a left into Fairview again.
Yannetti also tried to get in the fact that their investigator went to visit him. Nobody from law enforcement went to visit him. Lally kept objecting. The judge ended up keeping it out. But guess what? Lally ends up saying it later on cross that Paul, this other investigator, not Trooper Paul, was the first one to reach out to this guy who was driving the snowplow. So then on cross, Lally gets into the fact that he said he would have seen a body on the sidewalk or the lawn. And he's like, but there is no sidewalk. Aha. And there's no lighting on Fairview. And then he gets to kind of what he was focusing on. And maybe, this guy does have some vision issues potentially. Somebody said a learning disability. I have no idea if he had I didn't hear him say he had a learning disability of any sort, but he did have some potential vision issues and he did run into a basketball pole that night. So, there are issues there that might not exist with other snowplow drivers. And there's also more that Lally gets to in cross that, when something good comes out of cross, we're going to mention it.
No.
So do you know that there is actually no street lighting whatsoever in the area of a fire hydrant, a flagpole, or anywhere there for several hundred feet?
Correct.
You do know.
I believe so. Yes.
And so when you're driving by, you're looking for cars coming out of the driveway, cars coming in the opposite direction, people walking. Is that correct?
Correct.
And you're trying to look for those objects so that you make sure that you don't strike them or hit them or anything like that, correct?
Correct.
And on February 15th, 2022, when you had this meeting with Paul, you told him about 3:30 or 4 a.m. Is when you saw this Ford Edge on Cedar Place, correct?
Correct.
Now, in fact, when you first spoke to this individual named Paul, you didn't tell him it was a Ford Edge, correct?
No, told him it was a Ford Edge.
You didn't tell him first that it was a small SUV?
No, told him it was a Ford Edge.
Do you remember at any time Paul taking you on the parking lot and showing you different vehicles and asking you if those vehicles matched what vehicle you saw?
No, he wanted to make sure that what I was telling him was accurate. So he showed me what was a Ford Edge, but I had already told him it was a Ford Edge.
So we brought you out to the park.
He seems very sure and confident about what he said. And again, Lally's confirmed at this point that Paul was the defense investigator and the person that reached out to him first.
Parking lot at the skating rink that you were meeting at, specifically showed you a Ford Edge and asked you if that was a vehicle.
Correct.
Now, do you know sort of the difference between if you were to see a Ford Edge at nighttime in a snowstorm, the difference between a Ford Edge and a Jeep Cherokee?
Yes.
What's the difference?
The taillights in the back.
What about it?
Ford Edges are more round. The whole back facade is a little bit more round. The Jeep Cherokee are more square.
Now, what color was this?
That was a good answer by the witness. And Lally was like, oops. Azam said, potentially dumb question. No. Or might be, I've forgotten your explanation. If the defense has no burden to prove, why do they have a case in chief? Is it just more reasonable doubt? 386K subs. Yes, we're working our way toward 400K. So hit that subscribe button if you guys haven't already. So in this situation, so why does the defense have a case in chief? Defense has a case in chief because if they have evidence to present, if they have witnesses to present, if the defense wants to, if the defendant wants to testify for himself, they have the opportunity to put up evidence, to either poke holes in the Commonwealth or state or prosecutor's case to prove or create some reasonable doubt, to point the finger at a third party culprit and present evidence that it might be somebody else or that there's some other reasonable explanation. They have the opportunity to present whatever evidence they think is relevant to their defense. And that's how we balance it. The state gets to go first and last because they have that high burden. Stephanie, KR told investigators not long after this happened that Jo was beat up by Brian and Colin. Did somebody tell her that? Will they testify to that? I have no idea who's going to testify, so we're going to have to see how it comes out, but we heard her say it on the recording already. So do they really need to have somebody come testify to that? Nietzsche, should jurors infer defense's idea of witness importance from who questions them? AJ seems to get the key witnesses. Why Yannetti seems just as direct as AJ, though. I don't know. I don't know if they'll pick up on that. I feel like they probably group them. Like Little will handle maybe the medical type testimony. Although, she didn't. So I don't really know. I don't know how they're deciding it. Bethany, do you think the defense will recall any of Albert McCabe's? It makes sense why the Commonwealth called them first now. The shock has worn off. Hasn't really worn off to some people, I don't think. But what I will say is I have an idea of who the defense is going to call based on Yannetti. I think somebody sent me, I think it was Turtle Boy. I'm not positive, but I think somebody sent me a clip of an interview he did outside the courtroom today. So we're going to talk about what Yannetti said as far as what's left in the case at the end. Remind me, I'm actually going to make a note so I don't forget in my notes.
I can't tell you that. I am colorblind.
Can you tell, I'm just curious, sir, as far as your colorblindness, can you tell whether or not an object is dark or light just by looking at it?
I can see things that are light. I can see things that are dark. I can see true colors. I can't see shades of true colors.
And so from what you saw, was this light or dark?
Light.
So I think I was a little confused with the whole like light, dark. What can you see? What can't you see? Did he say the Ford Edge was light? Because if he did, that's obviously not great. And that's inconsistent from the black Ford Edge. So I'm not positive.
Now, you told this Paul individual on February 15th that the SUV that you saw was exactly where Mr. O'Keefe's body was found, correct?
Correct.
How do you know where his body was found?
I told him specifically if he was looking at the door, the front door, it was about 3 feet to the left of the door. And
To the left of the door?
looking at the front of the door, to the left of the door, pushing it up Fairview.
So if he wrote in his report that you told him that the vehicle was exactly where the body was found, that would not be true?
Objection.
No, I'll allow that.
Could you repeat that question, please?
If he wrote in his report that you told him that the SUV was exactly where the body was found, that would not be true, would it not?
That would be true. The car was to the left of the door, putting it in front of the flagpole.
My question for you, sir, is how do you know where Mr. O'Keefe's body was found? At any point in time, did you see Mr. O'Keefe's body on the front lawn?
No.
So how do you know where Mr. O'Keefe's body was found?
Through police reports, police interviews, stuff that was posted on the media.
So you've seen police reports in the media?
Well, not the police reports, I'm sorry, but what was said during On the news?
So what you've heard on the news, not
So first off, just so this doesn't go crazy, wait, you believe Turtle Boy. So let me be as clear as I possibly can. Okay. I have not followed all the reporting on this case. I know nothing about the beginning of this case. He posted a video where Yannetti was talking about the witnesses he's going to call. We are going to talk about what Yannetti said. So just relax, everybody. We're not talking about any reporters on either side of this case. I know people believe heavily and are very passionate and have dedicated a lot of their lives to each side of this case. It's not at all what we're going to talk about. We're talking about what's happening in court, period, the end. And if somebody posts a video, I'll give credit to the video that they posted of the lawyer that is answering the question. Okay?
necessarily what you saw or what you know yourself, correct?
Can you repeat that question, please?
You're recounting sort of what you've heard or saw in the news. So this doesn't come from your personal knowledge or anything about where Mr. O'Keefe was, correct?
Correct.
Now, you also spoke with some other
If
individuals.
people can't handle somebody's name being said, that's fine. I don't know what else to tell you. If somebody posts a video that I know posts a video, I'm going to say who posted the video. And I don't feel bad about that. I'm not going to apologize about that.
In May of 2023, correct?
Correct.
Now, did you tell those individuals that you actually came in? And when you say came in, you come into sort of the main sort of hub or the shed on Boulevard Street, correct?
Correct. We punch in.
That's where you punch in and you pick up your truck and you sort of do your checkpoint around the truck and then you go out and plow.
Correct.
Now, you were plowing on this street. Was there any other sort of subcontractor or anything else that was working plowing the roads as well?
Yes.
And who was that?
It was by the yard landscaping.
And so they assist as far as the plow route is concerned, and they go around and they plow things on the same route that you would describe, correct?
Correct.
Now, these other people that you talked to in May of 2023, did you tell them at that time that you actually came in around 11:30 p.m. to 12 a.m.?
I don't remember that.
You don't remember?
Here is another big part, okay, that I think went very well for the Commonwealth. He has these inconsistent statements, and Lally's going to go through the inconsistent statements, and they're important. The timing, the differences are very important. And again, a lot of Commonwealth witnesses had the same type of inconsistencies, and people hammered him for it. So the jury's going to have to determine what is correct. What is his real statement? Is it what he gave in court, or is it a prior inconsistent statement that is actually the truth? And I will tell you, without these inconsistent statements, this testimony would have been exceptional. With these inconsistent statements, with the color blindedness, and with hitting the basketball hoop, so maybe not the best vision and, paying attention to everything on the road, those are some hits at this witness, which is supposed to be what happens in cross.
That or you didn't tell them?
I don't remember that.
So that would be a significant difference, 11:30 p.m. to 12 a.m. from 2:15 a.m. to 2:30 a.m., correct?
Correct.
Now, you also indicated to them at that time that you went past Fairview at approximately 12 a.m. and 2 a.m., correct?
I never did 12, but it was definitely 2:30,
So if they wrote
2:40,
that in the report, that would
2:35.
be inaccurate as well, correct?
Sustained, and only one person can talk at a time.
Michael, I'm sorry, sir. Please continue and finish your answer.
I didn't hear the question.
Okay. Well, let me ask it again. So as far as if that was contained within a report regarding that conversation in May of 2023, that you went past Fairview Road or went down Fairview Road at 12 a.m. and 2 a.m., that would not be accurate, correct? Okay.
Sustained, ask it differently.
Did you go down Fairview Road at 12 a.m. and 2 a.m.?
No.
If that were contained in a report of your conversation you had in May of 2023, would that be accurate? Okay.
Sustained, ask it differently, Mr. Lally.
Now, as far as that conversation that you had in May of 2000,
Yeah, Lucky was only confused at the time, 5:30, 6:30 when EMS were there, but I think he explained it at the end. In my opinion, he didn't really explain it great, because if on his timeline, he went back. So he was there at the first time on direct. I think he said he was there at 2:45. Then he went back 3:15, 3:30. Then he came back 3 hours later. That is 6:30. That's not 5:30. And then he testifies to something different on cross. So I do think it was a little bit confusing on the timing. Was it huge? Was it the end all be all? Do we not believe anything he said? No. But I do think what's good for the defense, even though I think the Commonwealth had a good cross on him, attacking his credibility a little bit, again, not saying he's a bad guy, not saying he was lying, just some inconsistencies potentially that was already brought up by law enforcement before as to why they didn't believe he was credible. But you as the jury have to determine, do you think this guy just straight up lied? And I don't think he did. But in order for the Commonwealth's points to be well taken, he would have basically had to straight up lie, because he said, no, I did not say that. I don't remember saying that. This is my testimony. This has always been my testimony. Kevin said Bev prohibited third-party culpability defense. Don't forget. So she prevented the defense, but not the ability to present evidence of that. So we'll see. Ford Edge, Higgins, or Colin Albert. I get confused as they talk through the Ford Edge and the Jeep Cherokee and the white and the black and all this. I don't feel like it's very clear from me personally.
23, did you tell those individuals that you saw the vehicle around 1:30 or 2 in the morning?
Again, I don't remember ever saying that.
I agree. KZeddy. I don't know why this guy, you're right. Why is this guy's testimony so important? Why do we think it's such a big deal that he didn't see him at 2:30? Why do we think it's such a big deal he didn't see him at 3 o'clock? 10 people walked out the front door and didn't see him. But their testimony is, I wasn't looking at the front lawn. But he's actually just testifying consistent with what the Commonwealth said, right? Except he said he was looking and he would have seen a body. That's the only difference in the testimony.
Is that accurate as far as whether or not you told them that?
Again, I don't
Oh,
remember
this was
saying
the Proctor report? I must have missed that. Did the defense say that? I must have missed that. That the wrong times were in a Proctor report. That would change things for me.
that.
Did you see a vehicle around 1:30, 2 o'clock in the morning?
I wasn't on the road at 1:30 or 2 o'clock in the morning.
Correct. Now, do you also recall telling those individuals that Fairview Road was blocked off by cruisers at about 3 or 3:30 in the morning?
Again, that would have been incorrect.
You recall saying that in May of 2023?
I do not.
May I approach, Your Honor?
Yes.
So he gives him his statement to review. And a lot of people are saying that was Proctor. Now, I must have missed that. That definitely helps the defense with this impeachment of his credibility. But he denies it anyways. He denies that that's correct. He says what he said today is always what he said, and it's always been correct. He met with Yannetti twice, Tuesday and Saturday, and with Paul. They just confirmed, what his testimony was going to be. Lally ends by confirming that he was so sure about all the times that he drove by Fairview and what he saw, but he could not be sure. And he was asked multiple times, when you actually hit the basketball hoop, that you reported that you hit. Where do you think he got that strategy? So are you as sure about that as you are about this? The defense did that with multiple witnesses. So Lally kind of took a page out of their book. On redirect, he said he never saw a Lexus in front of the house, including at 5 a.m. On recross is when they kind of got into, was it 5 a.m.? Was it 6:30 a.m.? Based on it, it's kind of confusing. But overall, I thought he was a good witness. I wouldn't say an A+ just because there were certain credibility things that the Commonwealth did pick out during cross. Then we get to Dr. Russell. They went through her education experience, which I think is potentially the best in the whole case. We haven't gotten to the accident reconstructionists yet, but they go through all of that. She was a police officer, also taught while she's in the ER, tons of experience, 500 to 1,000 animal injury cases, obviously lots of car accidents too, even though she wasn't really allowed to testify about them, which I think is crazy based on her education and experience. She reviewed the hospital records and the photos. She's reviewed more than she did on her voir dire, which we'll talk about later. But we finally get to the opinion, her opinion in this case near the end of her direct.
Yes, it reflects the injuries that I saw in photographs.
All right. Now, based on your review of all of the data that you've talked about, all of the information that you were given and reviewed, what is your opinion?
I believe that these injuries were sustained by an animal.
Lacey, there's a lot that wasn't recorded in this case, right? Like the interviews. That would have been nice.
Possibly a large dog because of the pattern of the injuries.
Could you describe for the jurors, please, on what you
She
based?
said it was an animal, possibly a large dog, based on the pattern of the injuries, which she's now going to explain to the jury.
That opinion.
Yes. Well, may I use the?
Sure.
Okay, thank you. There's a number of patterns here. There on the upper part of the arm, there's parallel lines, and those were inflicted by either teeth or claw marks. So there's a number of patterns that could be teeth or claw mark. And so this is one set right here. This is the one further down, closer to the elbow, is another set of parallel marks, again, probably most likely from teeth marks. And the reason I say that is in addition to the parallel marks up here, down here, there's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth.
Okay, that was my question. What relevance does that have to your determination that this was likely caused by an animal?
So, David, I do agree with you guys. Everybody that's saying you can't believe anything Proctor touched, because that's kind of how I feel at this point with his credibility. I missed the part where I guess they said Proctor wrote that report and the prior inconsistent statement for Lucky. So that definitely would change if another jury, and this is why it's awesome, right? All these people watching together. So I would say that, I don't know, should we think about his credibility? And somebody else said Proctor wrote the inconsistent statement. I'd be like, all right, I'm with Lucky. I'll definitely believe that guy over Proctor. You wouldn't have to ask me twice. And that's pretty sad that that's how we all feel about the lead investigator on the case. Even the people that are with the Commonwealth, I think, have to agree that his credibility is pretty shot. And Nora agrees.
Yes, and I can explain in a moment the various kinds of wounds that animals can inflict. But going on with the picture first. So then down right at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth, in my opinion. And then there are some irregular wounds down just below the elbow. And these are all, by the way, on the exterior surface, or what we call what doctors would call the posterior surface of the arm, which is the part of the arm that would sustain defensive type wounds. So if someone were to protect themselves.
Objection.
So sustain. Next question.
Sure. Doctor,
I don't understand why she can't testify to that. Like, but whatever. Like, God forbid we actually start talking about the mechanism of how he moved his arm to have the injuries look like this. I mean, just staring at him like this while she's talking, you do picture a dog creating these, right? I mean, I do picture that.
Another question.
This is why the trip and fall and accidentally hit his head. These injuries are why it's hard for me to wrap my head around that. That would be a simple world and simple answer, right? Nobody did anything wrong. It was a freak accident. It sucks, but somebody should not go to prison for the rest of their life about it. But these are the things that make me, it's tough for me to get behind that one.
Just to clear up what you said a little earlier about something wounds close to the elbow, is it your opinion that both the top teeth and bottom teeth could have created some or all of the injuries on that elbow area?
Yes.
Okay, so in other words, instead of the mouth going all the way around the arm, the top and bottom jaw could have situated itself on this portion that we're seeing, the posterior part of the arm?
Yes, and in this case, the animal did not get a good enough contact.
Objection. Move to strike.
So I'm going to strike that. Ask a different question.
Have you seen?
So basically they're saying like he didn't grab good enough for it to make different kind of wounds. And then at the end here, we get what her final actual opinion is on whether or not this is consistent with an animal injury.
Okay.
Does the pattern of injuries that you see appear consistent with an animal or a large dog?
Yes.
Does the number of injuries that you see here relegated to just the right arm, is that also consistent with an animal or large dog?
Yes, it can be.
Is the direction of the injuries, or the consistency of the direction of the injuries, or parallel injuries, is that also consistent with an animal or large dog attack?
Yes.
Based on everything that we've discussed today, Doctor, is it your opinion, based on a reasonable degree of medical certainty, that these injuries were from an animal attack, possibly a large dog?
Yes.
Yes.
That's all I have this time.
So some questions about Lucky. Michael said, are we to believe he remembers the exact time he passed Albert's house, but has no recollection of the time he was in an accident with the basketball net? Again, I don't know. One of the reasons for this I could think of is potentially that he's been asked about this multiple times. So he remembers it because he was remembering back at the time, but nobody asked him about the basketball hoop back then. So it hasn't been kind of as burned into his mind as that, but I think it's a fair criticism. Sue, Peter, what do you think about Lally's tone towards the witnesses? I felt it was unnecessary and turned me off. It was more aggressive than I was expecting. I'll say that. It was definitely more aggressive than I was expecting. I'm not a fan of it. When you have kind of a gruffled kind of like, he has kind of like that kind of voice already, and you're interrupting witnesses and speaking over them. I don't think juries usually like it, especially with witnesses like this. And he comes out firing on cross, talking about her education and experience, which I thought was almost laughable based on some of the people he's put up on the stand and their education and experience. And he makes it seem like just because the last time she was in the ME's office was 95, that she somehow forgot what that was like, as if she hasn't been working in the ER for the last, 20 plus years or whatever it may be, teaching people, instructing, being a, adjunct professor type. He impeaches her or tries to impeach her by saying she looked at a bunch of files that she said she hadn't looked at before. And somebody asked a question about that. I don't remember where it was. So some people ask questions like, is she allowed to do that? So sure, she's allowed to go look at whatever she wants to prepare for her testimony. But because she said she didn't look at it before and Lally didn't have an opportunity to ask her about opinions on those things, the judge could have rightfully not allowed her to testify to them. But Lally was the one really asking her questions about those other files. So I thought that was interesting. He did ask about how she became aware of the case. She said an article in the Boston Globe. What was interesting about this is Lally tries to like impeach her and says, I guess we can play it. It's not really that important. Let's play it real quick. See if I can get that part.
The Boston Globe
Yes.
about this case, is that right?
Yes,
And how did you come upon it? You have a subscription to the Boston Globe?
I did at the time. Yes,
At the time. What time was this?
in May.
May of 2024?
Yes,
And how long had you had a subscription to the Boston Globe at the time that you saw this?
it was either a 6-month subscription or a year. I don't remember.
And that was the first time that you had seen anything about that?
First time I paid attention to anything like that. Yes,
Now, again, you had testified here just a couple of days ago, and I asked you questions about this. Is that right?
yes,
It wasn't in your testimony just a couple of days ago that the subscription was actually for a year or 18 months.
No.
Remember, not 6 months a year.
So only one person can talk at a time. So
So I went back and listened, or somebody sent me the clip or something, and she said 6 months to 12 months. So I don't know why and it doesn't even matter. Like, this is the type of stupid stuff you don't want to do on cross because it wastes time. It makes you look like a bully. It makes you look like a jerk. The judge has to jump in, and it just doesn't. Does anybody in the chat, especially the Karen Reed is guilty and she needs to go to prison for the rest of her life, any of those in the chat, do you think it's a big deal whether this witness had a 6-month, 12-month, or 18-month subscription to the Boston Globe? Does anybody care about that? I just don't get it. I don't get why that matters. Let's stick to the stuff that matters. If you want to hammer her credentials and you think that's a good argument, go for it. He asked her about this article. I thought she stumbled around a little bit. And, I thought it was pretty good. I do think the defense handled it on redirect pretty well too, but let's listen to Lally kind of spring this article on her that basically says what she's testifying to is inconsistent. At least that's what it sounded like on cross.
say that again, Mr. Lally. What's the report?
The National Academy of Sciences 2008 report in relation to the section referring to forensic odontology.
I'm not familiar with that specific report. No.
So then you
So
equally
in case you're
unfamiliar.
wondering, it is fair game to ask experts about reports on their expertise, even if they haven't read them, because they're supposed to be the expert on this.
With the representation that is not from the NAS report, that is not reliable science as far as bite marks.
There are certain aspects of bite marks that have been deemed not reliable, and that I believe has to do with saying that this particular person or animal inflicted this particular bite. But that's very specific, and that's what I'm aware of.
So she actually explains it right. At first, I was like, woof. Is she saying that people said what she's testifying to is basically junk science? But then when she explains it like that, she's not saying that Chloe had these specific bite marks. She's just saying it's consistent with the dog, and the jury can fill in the gap and they can infer things from the evidence. So she saved herself, and then again on redirect, they rehab her as well.
Recommendation.
You're not aware of any findings in the NAS report that led to questioning the value and scientific objectivity of such evidence.
For specifically identifying a bite mark to an individual that might have inflicted the bite mark, I think that's what that applies to.
Okay, I'm not asking, again, this is a report. Are you familiar with it or are you not familiar?
I'm familiar with a summary or a abstract of a report that indicates that forensic odontology is not is deemed not reliable when it comes to that particular narrow aspect of forensic odontology.
And so you're not familiar with it also, talking about sample data and collection, analyses of these, interpretation and reporting of results. You're not familiar with those areas of the NAS report as well?
But what specifically, do you have a specific?
I think he's trying to be too coy here. I thought it was good at first. Once she explained it and he kept going, I was kind of like, just show her the article and let her read it if you really care and you really want to ask her about it. I don't know if anybody else felt that way.
A question about that, or?
First question was whether or not you're familiar with the report. You indicated that you weren't.
I did not read the report.
Mr. Lally, let the witness answer one question at a time, one speaker at a time. Doctor, can you answer that question?
Sure. I did not read that report.
Now you had
Wafa, one of the differences is a lot of the times when Yannetti was getting aggressive with certain witnesses, they were also argumentative. They were usually cops. Sometimes they were doing things that were shady, or at least, did I say Yannetti? Jackson. He was like offended or acting offended. So it kind of played into what he was trying to do. I also did say I didn't like it a couple times. And I said it's more aggressive than, kind of the style I like. Sometimes I think it's appropriate. With this witness, I think it's totally inappropriate. And I would never cross this witness like that. And there are a lot of reasons for it. right? And you just don't need to make your point. I think he had a point to make. He can make it. He doesn't need to be so gruffled about it. That's just my opinion. And people can disagree. And I absolutely thought Jackson was too aggressive with certain witnesses. And I thought it was spot on perfect with some that absolutely he needed to treat them that way. So I think it all depends on the circumstances.
Written some articles that you were asked about in reference to dog bites, canine dog bites in the emergency department. Is that correct?
Yes, co-authored.
Something that you published or authored or co-authored sometime in the late 1990s. Is that right?
Correct.
And in that instance, you talk about law enforcement dogs and a bite and a hold technique, correct?
Yes.
Now, part of the reason in writing that article had to do with sort of the applied forces and the unique spectrum of injuries from those kind of dog bites. Is that correct?
Yes.
And that spectrum of injuries would include deep puncture wounds. Is that right?
It can. Yes.
Severe crush injuries. Is that right?
Correct.
Large tissue avulsions and lacerations. Is that right?
Yes.
Wounds necessitating surgical debridement. Is that right?
Yes.
Bony injuries ranging from portable violations to displaced fractures. Is that right?
Yes.
Neurovascular.
I think what he's doing here is he's trying to differentiate her expertise and her articles on what happened in this case, or to say those injuries are all much worse when they're from a dog than what you see to John O'Keefe's arm, not to his head, but to his arm, which again, I thought was decent. I think she does seem very smart, but she did seem a little nervous after, they started going through the article, and then she was a little confused about the DNA and stuff like that. So I think, there were ups and downs. I think overall she was a really good witness, especially on direct. I do think the cross, while the style wasn't always perfect, I think he made a couple of points. And I think if his style would have been a little different, I would have liked the cross even more. Neil said, why wouldn't they swab it for animal DNA? You got me. I have no idea why. I literally have no idea why. Then, after the defense did not get into Chloe's other bites, Lally decides he's going to, which I thought was kind of interesting.
Above the small round punctate abrasions, I believe that those are bite marks from upper and lower teeth.
I've heard this, Rebecca, as a theory from some other people as well. I don't know. It's possible.
Indicated that's part of what you
But again, that's not what the Commonwealth is saying.
Reviews was a dog bite history for a dog from 34 Fairview Road named Chloe. Is that right?
Yes.
And there were a couple different instances of that dog essentially getting in a fight with other dogs, correct?
Yes.
And at any point in time, did you see anything in there as far as a dog going after a human in which there was no other dog present?
No.
And there were actually photographs contained within that material of dog bites from that dog, from Chloe, right?
Yes.
Did any of those dog bites that you saw in those photographs look anything like what you observed in the photos that you saw of Mr. O'Keefe's arm?
No, but. Okay.
Objection.
No, so the answer is no. You can get back up, Mr. Jackson, but the answer to that question is no. Next question.
So, is it your is consistent with an animal attack to the exclusion of any other possibilities? So, is it your testimony that from reviewing what you review, that what you observe on Mr. O'Keefe's arm is consistent with an animal attack to the exclusion of any other possibilities?
To a degree of reasonable medical certainty, yes.
So as far as any other sort of blunt impact injuries or other manifestations of how those scratches got there, you're saying, nope, had to be an animal attack.
I've seen thousands of wounded.
No, what I'm asking you is.
All right. So, Mr. Lally, I'm going to let the witness answer.
Go ahead, ma'am.
I've seen thousands of people with injuries to their skin, and from blunt, from sharp, from all different mechanisms. Those injuries did not look like blunt force injuries.
See, I agree with her. And I think it's weird that the Commonwealth witness said that like broken glass and broken plastic and claws, maybe she said paws, were blunt objects. But again, I'm just using common sense to do that. I'm not an expert.
So it's your testimony that the injuries to his arm don't look anything like blunt force injuries that you've seen before. You wouldn't characterize them as that?
That's correct.
So he also is asking her questions in a way that like defense attorneys sometimes ask when they have the goods and they're like, wait, hold on, let me lock you in. You're saying you think this happened from a dog or an animal, not from blunt force trauma. That's what you're saying. But we've already heard his testimony and evidence. Does he have something good coming on rebuttal? I don't know. But that's the way he locked her in, and he just got her to basically repeat her opinion in this case. Then on redirect, Jackson gets up, talks about the fact that the report has nothing to do with this case. It's more like like what Muserlina said, the dog bite is not like a fingerprint that you can use to say this was the dog that did this bite. Then let's just watch real quick Jackson try to get into her, overarching opinion again, like we saw Lally do with basically every expert witness and how the judge handles it.
The nature and the pattern and consistency of the injuries that you saw on Mr. O'Keefe's right arm. What is your opinion to a reasonable degree of scientific certainty about the nature of those injuries?
Objection.
Sustained.
What is your ultimate conclusion and opinion about the injuries that you saw and that you reviewed and that we saw today?
Objection.
Sustained.
Can you tell the jurors at the end of the day, what is your opinion and conclusion about those injuries?
Objection.
Sustained.
Can we approach?
He's like, please, Your Honor, please. So yeah, and after the sidebar, he's not allowed to do it. So he kind of finishes. All right. I'm going to answer some questions before we get to the last witness of the day. So I think those two witnesses provided some really important evidence for the defense, and they're moving it in the right direction. This witness, I didn't feel quite the same about. I know we're going to have some disagreements, and that's fine. Looking forward to them in the chat, but let me hit some questions here first. Do you think that people, maybe the jury, perceive witnesses as accomplices and this plow driver as a witness? Is it the defense's PR? Honestly, I don't think that usually. Now, if it's a family member or like best friend or something like that, maybe, but not usually for this type of a case with these other witnesses, maybe the connected ones. But was she allowed to go look at the info? Oh, here it is. After the voir dire and comment. Sure, she's allowed to, but she can't add to her opinion because the judge has already limited what her opinion can be. But of course, if she says she read them, then it opens the door for the Commonwealth to cross her. Just my insights. Could she be found guilty on both second degree plus manslaughter? No. How would that make sense? It was either intentional or not, right? Yeah. So that would be a lesser included, not two separate charges. Stephanie, I will say that I'm worried about the tow truck driver. He lives there and has known the Albert since grade school. How do you think this will play out for him if Karen Reed is found not guilty as she should? I don't know. It's really hard for me to speculate on stuff like that. I assume they won't be happy about it, but I hope not. And I don't think they would do something that would look a little too obvious at that point. John O, I usually question any expert that isn't hands-on. I seem to prefer experts who actually evaluated things in person. You think that normally fair? I'm fine with that because you would believe my treating physicians who actually treat the patients and have seen them 100 times versus a CME doctor that reviews records, meets with them for 5 minutes and writes a report. But I don't know. I think every expertise is a little bit different. Sometimes they can do experiments and things like that. Sometimes not. Amy, I love how he brings up an article that says comparing bites isn't accurate, then asks her to compare Chloe's bite history with John's arm. He brought up everything that was like off limits and opened every door that, I wouldn't think he would want to open, but the defense didn't really hammer it after. So it is interesting. Okay. So let's get to Mr. Green, who is the cell phone expert. I had been hearing rumblings. He was the expert of experts. He was going to be amazing. He was going to crush the state's experts, things like that. And he gets up, got some good experience in education, civil and criminal, state and defense, been experts all over the place. He was engaged in September of 2022. It seemed like maybe law enforcement deleted some stuff maybe in April. I wasn't really sure what that meant. He says he has studies that show the steps data on Apple are 98% accurate. He also did some testing himself, which I found to be very interesting, saying that it was accurate and didn't have you taking steps when you were really driving. That was interesting. He explains that how long to die in the cold was at 2:27 a.m. And we're going to listen to his, the end of his testimony, kind of what his opinion was in this case and the way he explained it.
Do you have an opinion as to the timing of that first search for Haslam to die in cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out itself, it's all consistent with that search happening at or before that time.
And what opinions or conclusions did you reach regarding how, if any, how the 2:27 a.m. search was deleted?
Well, we know that that's in a deleted state. And importantly on that phone.
That's not great. That's just a conclusion. We know that it's in a deleted state. Like that's some of the conclusions and stuff that he testified to. That's what it sounded like. We're going to keep listening, but like, I don't love that out of an expert personally.
is when I say I keep using the proverbial we, I found a lot of other that have been used or deleted artifacts between the midnight and the early mornings on January 29, 2022.
Okay. Are you aware of any internal mechanisms that could have caused that deletion?
No, not in this particular case. I know no mechanism that would have done that.
And you mentioned other deletions on the phone. I want to show you what has been marked, if I may approach. MMM for identification. Do you recognize what I placed before you, sir?
Yes, sir.
What is it?
Okay, this is from Cellbrite. It's a program, again, like the Axiom that processes data. And this is this lists out a 623. This lists out a deleted call record.
Okay. Are you able to see from that record to whom the call was placed?
Yeah, well, we have the number, and I won't necessarily read it out loud here, but through searching, and this is from the phone of Jennifer McCabe, but through searching for that the number, I was able to see that it went to. You want to say the name?
Sure.
Yeah, Uncle Brian A.
Oh, I would offer that into evidence, Your Honor.
Same objection as before, Your Honor. As when this was, may we approach?
Okay. This may already be in evidence. It's one of 4 different numbers, so I sort of wanted to keep it with that. We are so far removed from where it was that this will just come in as the next exhibit. So you will technically have it in evidence twice.
Okay.
Thank you. May I approach again, Your Honor?
Yes.
There's one final document before you. If you can identify that for the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data, and this lists out the call log with a number of deleted items and a number of live items.
I would offer that, Your Honor.
If I get to see, sure. It's already in evidence.
About this particular report here, it starts at 5:33:47 in the morning, and on the second page we see it ends at 8:50 and 15 seconds. Data, additional deletions.
And am I right that those are all, that's the call log, those are all phone calls?
Yeah, well, it's the state they were found in. Deleted versus live data.
I'm sorry?
Deleted data at the earlier time and live data after the 8:59:34.
What percentage of phone calls were found deleted on Jennifer McCabe's phone prior to 8:50 a.m. on January 29th?
So all right, I have to see you. Take this down for a minute, please. I have to see counsel.
You, from the first recorded call there, that was listed as deleted until 8:50 a.m. or so. What percentage of calls were deleted on Jen McCabe's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
Now, are you aware of the term spontaneous deletion?
No, sir. I know what the individual words mean, but in relation to digital forensics, I'm not familiar with that term.
And if you remember, that was like the last question he asked this Commonwealth's expert, and he's like, I wasn't aware of it until this case.
And do you have an opinion as to how those calls would have been deleted from that phone?
Those would have been used or deleted.
I made a moment.
Sure.
And that's the end of direct, that those calls would have been user deleted by the user who is in fact Jennifer McCabe. That was his testimony. 227 is when the search was, and she deleted the calls herself. Charlie, didn't the dog DNA come from the clothing that had been sitting in evidence room, spread out and drying from who knows how long? So the lack of dog DNA came from that. So if you're saying they maybe washed it off, I don't know. I think that's how the defense wants jurors to think. They want them to think it's all conspiracy, cover up, planted evidence, all that stuff. I think that's where they're kind of, running the ball towards. Ellen, are lawyers allowed to ask, is it more likely than not that, usually not, usually it's to a reasonable degree of medical probability or medical certainty or scientific probability or scientific certainty when you're talking to a witness, or is that consistent with, usually that's the verbiage used in these types of questions. Late to the party today, so this may have been asked, why can't they find the dog and measure the teeth and bite compared to his arm? So apparently there's an article that says that's not reliable, that we didn't necessarily know about, but now we do. And they didn't know where he was. Trial started, everything's going on, so they're not able to do that, and it's past the deadline to even have that evidence in. Rebecca, well, I got to go save some lives in the ER. Glad I caught some of this, and for the record, in 28 years, I have seen a lot of dog bites. It does look like a dog bite. However, science isn't perfect. Please have a safe weekend. Thank you, Rebecca. And that's an insightful comment there about it potentially being a dog bite. Okay, so now we get to cross. And he basically asks, are you aware that 2 Commonwealth experts disagree with you? And he's like, yes. He attacks his credit or his education experience certificates a little bit. Then it makes it seem like when he called Cellbright, he talked to people that worked for the Commonwealth's expert, and the Commonwealth's expert was supposed to be the one to help him, which obviously would look good on that expert. This guy's like, I don't remember that. I don't ever remember talking to that guy. I know he may have called me. I thought it was kind of an awkward cross. This guy was apologizing for frustrating Lally. Lally was kind of huffing and puffing a little bit. Lally definitely tries to use some of what his expert said on cross. And then this was one of the best parts for Lally in the cross. And this is why I thought this guy's testimony was mid at best. First off, I think they got to the point, which I appreciated on the direct. And I love when you get to an expert, but I don't feel like it was super clear or convincing compared to the state's experts that I actually thought did kind of a good job on the Cellbright stuff, except for the fact that what they're asking me to believe, meaning the state, is that what the report says is not true. So it's like, do I want to just go with the defense witness and with common sense? Or does it kind of make sense what the Commonwealth is saying, even though it's different than what the words say on the report? But these next 2 clips I'm going to play have me leaning pretty heavily towards the Commonwealth's explanation of the phone records. Now, on a scale of 1 to a million, how important do I put this on the scale of proving guilt of Karen Reed? Very low. At the bottom, frankly. Because this does nothing to prove Karen Reed did it. I know everybody's saying this is what started the conspiracy. I don't care. I don't care what happened before this trial. I'm looking at what's proven in this trial and what they did in this trial. This does nothing to overcome reasonable doubt based on what the Commonwealth's been presenting the last 29 days. So I can say that at the same time saying this was bad for the defense, in my opinion, these next 2 clips that I'm going to play.
Come up. I also notice the specific phrase, how long does it take to die from hypothermia? So as you do this Google search, you try to repeat what's being done. Those are 2 suggestions that actually came up.
And so that was something that was a suggestion and not something that was actually searched, correct?
Yeah, no, I know this different from my affidavit from about a year and a half ago, in all fairness, but
that's entirely different.
One person, Mr. Lally,
I'm sorry.
one person at a time.
Yes.
Okay. So yeah, in fairness, I want to give you my best knowledge as I understand it saying here today, including after my review of Mr. Whiffen and Ms. Hyde's report. So I want to do everything I can to shine as much light and clarity on this as possible. So as I repeated, since that time and did the search, I would notice that is one of the things that would come up, and it would have a little picture of like a dinner plate or something like that. And there was actually a similar, if not the same picture found in the artifacts of that phone.
So just to conclude, that's not what you said in your affidavit that was actually filed under pains and penalties of perjury with this court, correct?
Yes, and on.
So he basically is talking about the fillable Google suggestions that kind of prove when people search different things and when they click it and why they click it and what it proves that they actually typed into the search box, because we know what Google will fill it with, which is exactly what the Commonwealth expert said. He filed an affidavit that didn't say that. And now, after the Commonwealth witnesses have testified to this exact stuff, now he's admitting that what he put in his affidavit was wrong. That's interesting to me.
A similar, if not the same picture found in the artifacts of that phone.
And so just to conclude, that's not what you said in your affidavit that was actually filed under pains and penalties of perjury with this court, correct?
Yes, and on that day, that is what my true and proper belief was. Okay, it's since further testing, I have found that I now believe that was probably an automatic one, and if I've caused you any distress, I apologize.
I haven't caused you any distress.
Okay.
What I'm asking, sir, is that that's what you filed because that's what you thought at the time, correct?
Yes, sir.
And subsequently, you've done further testing, and that's shown that you were wrong, correct?
That is correct.
Now, according to your affidavit, there was a search for how long to digest food at 6:23:49 a.m. that precedes the search for how long to die, and the misspelling here would be the key CLKD at 6:23:51 a.m. Is that correct?
Yes, sir.
Now, is it possible that the how long to digest food was a predictive suggestion from Apple rather than a search entered by the user? Is that also correct?
Yeah, I don't know. I don't know the answer to that. I believe that it was, if it had picked up a earlier search from 227 of how long to die in the cold, and then you went to retype it in, it may have then tried to give you something similar at the 6:23 and 6:24 timelines. So hopefully that answers your question.
So steps, going to Mr. O'Keefe's health data, steps doesn't necessarily mean that someone is physically taking steps, correct?
Again, the research is done for this. Is steps tend to be a very accurate artifact.
So steps cannot also be coincided with, say, movement in a car or other sort of movement of the phone as far as the health data is concerned?
Sure. Well, I did, quite some time ago, do some testing with an actual iPhone 11, the same make and model, and took a drive and tried to see if it would register steps. It did not. I sat in a chair and tried to duplicate how I thought I would walk to see if it recorded steps. It did not. I took the phone from the floor to the ceiling to see if it would record a flight of stairs. It did not. The only
that I thought was good for the defense, that he had done these little tests that maybe the jury has done. A lot of you told me in the chat they had done. So I thought that was good that, you know, he said he did all these things and it didn't pick that up, which shows the reliability of the steps. So that I thought was good. So there are people, you know, some people liked Green. Some people didn't like Green, like Truth Be Told said. He was kind of like Trooper Paul, not as specific necessarily. I think probably the most plausible outcome of all of this is what Sarah said. The experts kind of just cancel each other out. I have a hard time believing the Commonwealth and a hard time believing the defense experts. It's kind of probably somewhere in the middle, or I just don't know what this actually proves. But again, you know what it doesn't prove? How John O'Keefe died, how it's possible the car hit him, how the Commonwealth is going to prove it. And it's pretty funny to read the chat. Stephanie says you need mods. We have mods, first off, but people go wild if you disagree with something the defense does. And I can't control that. I'm trying to tell everybody I have found plenty that's not perfect for the defense. That's bad for the defense. That's good for the Commonwealth. Nowhere near enough to prove this case beyond a reasonable doubt. There's also even more that's good for the defense and bad for the Commonwealth. And I've called it on both sides. I always will, regardless of what the chat, you know, says. And some people getting frustrated by that, you know, saying I'm being willfully blind or whatever. Like an expert saying he was wrong in his affidavit and then going back and doing the work that the state's experts had already done and testified to me adds credibility to the state's experts and take some of his away. People are saying admitting you're wrong adds credibility. Okay, but that's not good for experts to be wrong. It's just not. All right. And then, so they talk about the 3 clocks being connected to the power. I thought he did a good job handling those questions from Lally. You know how Waze is connected to the power support or whatever. So those clocks are actually with Waze. I think he left the door open for that to be reasonable doubt with the couple minutes up or down based on the 3 clocks they use that Yannetti asked their experts about as well. And then I thought this was potentially, you know, again, this is me who's not an expert. I'm just listening to this stuff, taking it all in. This was potentially the worst part of Cross, even worse than, you know, him changing his mind on what he already filed in his affidavit. And I'll slow it down so we can hear this.
More on where you can put multiple cases in and that. It's only the Insight versions that they have bothered updating and no longer report, right? So Mr. Whiffen's testing was not done with this specific version of the iOS.
So yeah, and that was his explanation, which we already knew based on the cross, that he's saying the Commonwealth did not use the right iOS. They say, the Commonwealth says he didn't use the right iOS. So again, pointing the finger kind of at each other, but I'll tell you when we get to the part, I don't know exactly where it is.
The iOS has been known to be changing the way this artifact works. To do proper analysis, the researcher that he would need to work with that same iOS. Now, in regards to the Cellbrite question, they have 2 versions of the Cellbrite Physical Analyzer. One is the standard physical analyzer that's been out for several years now, probably is majority use in the community. It's a tool that takes that raw data and it puts it into human terms that we can look at and understand and write reports like you've been seeing here. So they have the Cellbrite Physical Analyzer that's out there. I believe it's 7.68, but don't quote me on that. And then they have a new version that's come out called Insights, and this operates more on where you can put multiple cases in and that. It's only the Insight versions that they have bothered updating and no longer reporting on that time. Their current physical analyzer program, and I tested this a few days ago, still reports on that search occurring, and that timestamp. So currently Cellbrite is providing examiners, law enforcement, and people worldwide with 2 different versions giving 2 different results. That I can't speak to more than that, other than I've tested that, and I see how those programs are working now.
My question, sir, yes or no, is are you aware that Cellbrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with Asterisk, they updated 1 of 2 programs.
Did you hear that question? We're going to listen to it again. Listen to Lally's specific question and his answer.
And I see how those programs are working now.
My question, sir, yes or no, is are you aware that Cellbrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with Asterisk, they updated 1 of 2 programs.
Do you know that Celebrite has updated their, way of doing things because people misinterpreted data or misunderstand data the way you have done in this case? And he says, yeah, with an asterisk that they've updated one, but not two. We're going to listen to it one more time. Okay. Just one more time. Because explain to me. I'm sure people will be able to explain to me in the chat why this isn't that bad, because it sounds bad to me.
Celebrite has.
See how those programs are working now.
My question, sir, yes or no, is are you aware that Celebrite has had to modify their software based on misinterpretation of data, as you've done in this case?
Yes, with asterisk, they updated one of two programs.
Nothing further.
All right. To me, that's not a great thing for your expert, that they've had to update it based on it being misinterpreted the way you did it in this case. Maybe that's not what he's saying. Maybe I'm hearing it wrong. But if I'm on the jury and that's what, I ended and heard with, and there was no redirect, I don't think that's great. Personally. T-Shaw said, Peter, if there were no signs of a cover-up or police misconduct, why would the FBI get involved? Seriously asking, not meaning to be as a gotcha. No, not at all. I appreciate questions, even if, you're asking it sarcastically because you think it's obvious. So you said two things there, a cover-up or police misconduct. I think there's absolutely police misconduct. And that's the number one reason. Maybe they do believe there's a cover-up and that's why they're investigating it. I think there is definitely some evidence of it, but the defense doesn't have to prove that. And that's been kind of my big thing throughout is they don't have to prove it to this jury to win this trial. P.S. This is me, said I need legal advice. May I email my problem? Yes. lawyeryouknow@gmail.com. Quantum Thug Life. The untested blood on cups. Wonder if they have tested positive for canine also. Didn't canine go to the friend family? Why isn't the dog accessible? Would there be canine or glass taillight in the wounds? A lot of questions there. They rehomed it. The defense did not know where it was. They weren't able to do any testing on it. Doesn't seem like they tested the blood in the cups for canine DNA, just swabbed the shirts. Thank you, Dr. Elise, for the super chat. Tim, I'm not an expert, but I could be a juror. Those scratches do not look like dog bites to me. If the case came down to this one point, I'd likely go against the defense. So here's my question though. Going against the defense does not mean a guilty verdict. So you would have to say that you believe they are from the tail light exploding and scratching his arm when it hit him. So is that what you believe, Tim? Do you believe the tail light caused those scratches and that the car caused the damage to his body? That's the question for you. Is what the defense is proving is true. That's not the question. Is what the state is proving true beyond a reasonable doubt? Which if you think yes, then you'd vote guilty. Most experts are wrong, but tech changes so much. So, okay, I agree. I would hate if my case relied on this because it is hard. Everybody wants to act like an expert or acts like it's easy. I really don't think it is. Maisie, he agreed to in part and not the other. Okay. The state spends millions of dollars on a case, but not get the right phone operating system on a murder case. Ginny, I think the jurors are drawing turtles on their notepads during the cell phone testimony by now. It just doesn't matter. And very well may be where they're at. Tooth Hurdy said long-term issues with the Commonwealth disproving Celebrite data in open court. Well, it seems like Celebrite is updating it. So maybe it will become more correct. I don't know, like more reliable, more useful. Because if you say deleted and it doesn't mean deleted, and you say 227 and it doesn't mean 227, it's totally useless. Azam said, Peter, saw the Civil Procedure Rules Committee, sir. What does that mean? 2018, 2024. So you're no longer in that committee. Story time. Loved last night's story. Yeah. So it's 3-year terms is all you're allowed to do. Then you have to term out. So I'm off the civil rules now as of yesterday. But I'm probably going to join another one in the next year and get on a different rules committee. I like being on I like being on them. I like learning. I like being involved in writing the rules and helping with stuff. So my time on civil rules is done. I think I can go back on later after so many years off. I did love that. That's the one closest to what I do, but there are a couple other ones that are really integral in what we do every single day. So I probably will still join another one. Hope said, I'm Googling how long until Lally stops talking. Can't wait for Jackson's closing argument. Yeah, I would assume it's going to be Jackson. But let's talk about what's left in this case. So Yannetti in the interview said they only have 3 witnesses left. the pathologist, and the 2 accident reconstruction guys. So to me, based on timing, it seems like they're going to be done Monday night, Tuesday morning. Will the state have a rebuttal? If they do, how long will it be? Only God knows. But if they don't have a rebuttal, or if they have a short rebuttal, it's possible we could get closing arguments, in this case to the jury, by Wednesday, which would be wild. I am going on vacation Thursday and Friday, so hopefully no verdict there. If there is, I will bring my stuff with me to stream and talk about it. But that means no Karen Reed, right? He didn't even say maybe our client will testify, maybe she won't. He said, we got 3 witnesses left, pathologist, 2 accident recon. And they're very confident in where they're at right now. That's straight from Yannetti's mouth. Welcome, Matthew. Mara C. Commonwealth used the wrong iOS for testing. Like how? Their expert said it was close enough and it wouldn't have made a difference. That's what he said. You don't have to believe him, but that's what he said. Patrick, just getting the dog bite in was a huge win. Yeah, and that evidence, I agree. I think it was a big win. Best to be on the side of justice, not the Commonwealth or defense. Thank you, Christina. That's where I try to land in every case. I do my best. John O'Rourke, could it be suspicious that the Commonwealth didn't present the DNA or teeth structure of Chloe? And I think KR did it, but requesting more info, fair is fair. Well, if you think you need that info to disprove that reasonable doubt, then you would have to vote not guilty. That's the point. If that's created a reasonable doubt in your mind and you're like, the Commonwealth needs to the exclusion of, they need to exclude all reasonable doubt. And if they didn't without that information, that's a lack of evidence, and you as a jury would be well within your rights to vote not guilty. Marcia, my husband is an ER doc, and when I showed him the picture of John's arms, he immediately said dog bite. Maybe he should text Alan Jackson's friend and he could be the next expert witness. Family account. The question can be interpreted, are you aware it needs to be updated as you've done? Or are you aware it has been misinterpreted as you've done? Both work grammatically. One is fine for an expert. Didn't sound like that to me. But again, if you're sitting there on the jury and you think that's what it sounded like, we'd have that discussion. Miss Esk, Peter, do you think Karen will pursue a 1983 civil rights action if she wins? I think she will absolutely pursue any and all civil actions that she can. Peter, will you cover the writ of mandamus on Judge Glanville? Lorna, I'm so glad you sent this text. It's a perfect transition. Tomorrow morning, 8 a.m. Saturday, my dad and I will be breaking down the writ of mandamus in the YSL trial. We go into it. And we talk about what we think is going to happen, why they're even in this position, how unusual it is. So don't miss it. Make sure you subscribe and hit that reminder bell. Joe, will Celebrate copying to its issues? Could this open up appellate issues on other cases where Celebrate data is a material fact the jury decided on? I think so. I think it's possible. I don't know, but I think it's possible. Kevin said Karen was a professor of mine. She was great. Not guilty 100%. Interesting. Tim, why would Reed testify? There's nothing she can do to help her case on the stand. Well, she said she wanted to, and sometimes defendants testify even when, the general public think they shouldn't. All right, I got to go. I'm out of time. How long do you think deliberations will be? Couple days. I think it'll be multiple days. Tracy G, looks like he got attacked by a dog, fell, hit his head. No one knew he was there. Called the dog back in the house. Cops assumed KR hit him and made the case fit. I think there's a lot of plausible explanations. I'm not sure what happened, but that's up for the jury to decide. The defense is presenting their case now. That's all we got for this time. Please hit that like button. It helps so much with these videos, especially for the rewatch crew and for people to see it and push it out there on YouTube. And subscribing also helps us a lot. We're pushing to 400K. We'll see if we can get there by the end of the trial. It's kind of a crazy goal, but it would be awesome if we did. I appreciate everybody who always joins us. It's amazing. You guys are amazing. Even when we disagree, even when it gets a little heated, it's okay. We can always come back to being big fans of justice, which we all are in this chat, at least hopefully. All right, till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.